Josh, good to see you again. Boy, do I have a list for you. This is what happens when the guy whose legal training is all from watching Law and Order and needs to talk to a real attorney. So thank you for being here.
You bet. Always a pleasure, Sean. Thank you.
All right, let's stop at the top of the list. Last night, President fires Lisa Cook, the Fed governor. This is what I have been saying all day today, so tell me if I'm wrong. The media keeps saying that she hasn't been convicted of anything. And my answer is, that's great. The law says it's just cause. So explain what the what's the level that you I don't know, like what constitutes cause?
Okay, so there's various levels here. First of all, the notion that a federal employee has to be convicted of a crime in order to justify the chief executive, the guy who actually wields the executive power, the notion that there has to be a crime for the president to fire that subordinate in Article 2 of the Constitution is utterly ludicrous. Now even kind of taking it as it is, this purported statutory requirement that certain federal employees must be fired for a cause, Sean. Cause obviously and transparently does not mean that you have to be indicted, convicted. If that's what they meant, they would have said that. The statute would very clearly say that a federal employee can be fired upon being indicted or convicted or various other levels of the entire criminal justice process, which is a pretty lengthy process. What about appeal? I mean, there's a lot of intricacies here. The drafters of the statute would have specified that. Rather, for cause, really just means that you just need a legitimate cause here. And on its face, what Lisa Cook is doing when it comes to mortgage fraud strikes me as a pretty reasonable cause there. It's worth noting, by the way, that Lisa Cook was only confirmed on a 50-50 vote with Kamala Harris casting the tie-breaking vote. This is someone whose qualifications have been considered pretty dubious for a long time there. I mean, not even Murkowski, Collins, none of the squishy Republicans even cast a vote for her to be a Fed governor. But I think the most important point here, Sean, to make there, and this is kind of coming from a structural constitutional perspective, I don't think you even need this statutory for cause requirement. To the extent that Congress enacts any hurdles whatsoever to attempt to inhibit the president's ability to manage his or her executive branch, to hire and fire employees as he or she sees fit, to the extent that a statute purports to do that, that statute is facially unconstitutional, period, full stop, end of story. And we've already seen some interesting rulings over the first 7-8 months thus far of this Trump administration that kind of indicate that the Supreme Court is probably likely getting prepared to make a sweeping ruling along those lines. There's actually a case from the 1930s here that has been very much in the crosshairs of us legal eagles for a very long time. It's called Humphrey's Executor, which is kind of one of the infamous New Deal FDR era cases from the mid-1930s that says that Congress can legitimately inhibit the president's ability to fire executive branch employees under certain circumstances. But as part of the litigation earlier this year against Gwen Wilcox, who was a Biden nominee, a Democrat nominee to the National Labor Relations Board, the Supreme Court actually seemed to green light President Trump's ability to dismiss Gwen Wilcox. So there's a lot of favorable tea leaves out there. And I guess I'll just end on this. Look, the Federal Reserve, more generally speaking, Sean, coming from just a bread and butter, originalist, constitutional law 101 perspective, the Federal Reserve is in Article 1 of the Constitution of Congress. It is in Article 2 of the Constitution of the Executive Branch. It is in Article 3 of the Constitution of the Judiciary, or it doesn't exist at all. This notion that there is anything that is outside of the normal chain of command of Article 2 of the Constitution, the Executive Branch, is completely and utterly preposterous there. So I say this. I say that Donald Trump has the ability to fire Lisa Cook and, frankly, anyone he wants at the Fed or literally any other agency in D.C., period, full stop, end of story, or the Fed or that other agency is unconstitutional.
Hey guys, I hope you're enjoying this conversation, but if you're looking for a way to get to sleep tonight and stay asleep, I've got the answer for you. For over a year, I've been taking Beam's Dream Powder. It has made a world of difference. I fall asleep faster, I stay asleep, and I wake up ready to go. If you want to join me by taking one scoop every night before you get to bed, go to shopbeam.com/Spicer. Use code word Spicer at checkout for up to 40% off. Trust me, everything stems from a great night's sleep. Go to shopbeam.com/Spicer, code word Spicer. All right, back to the conversation. And don't fall asleep yet. Would you, if you were going in front of the Supreme Court, I'm just asking this objectively, based on all of your constitutional law training, would you cite the case of Spicer v. Biden at all?
I think it's a totally legitimate point. I mean, Sean, I'm not familiar with the cases you are, but based on my memory of the details there, yeah, I mean, that's kind of what we're talking about here, right? I mean, we're
well, Biden fired me. We sued him through America First Legal. We went to the appeals process, and the court, all the way through the appeals process, affirmed that the president of the United States had the right to fire people that he named to stuff.
Exactly right. Yeah, look, I mean, that's very clever, actually, right? I mean, that would be a very clever way to try and make that point there. But, I mean, this is bread and butter Article 2 core constitutional power stuff. I mean, if the executive power does not entail the ability to make all personnel decisions, hiring and firing within the executive branch, then the executive power means nothing at all. It is the absolute crux, the bread and butter of what the executive power entails. You, by definition, are not an executive if you don't have plenary sweeping ability to control the literal people constituting your branch. So then applying that to the Federal Reserve, again, the Federal Reserve either sits comfortably within this well-established Article 2 executive branch chain of commands, or the Federal Reserve is off in la-la land, in no man's land there, and that's taking us to a very interesting place there. You know, I guess it's just one final historical note. Sean, a lot of people are freaking out about this. Oh my God, Donald Trump is acting like a fascist, a dictator there. I mean, you know, consider opening up a book of American history. I mean, presidents warring with central banks goes back a really, really long time. I mean, Andrew Jackson, the second Bank of the United States, are you kidding me? I mean, John Marshall and the Federalist Party versus Thomas Jefferson, the first bank back in the 18 teens. You know, this notion that presidents, that it is dictatorial or fascist who try to get involved here when it comes to the central bank. I mean, literally just open a history book, for goodness sake.
So the interest, just like what I want to underscore though is when we talk about cause, because I loved your description at the beginning, but just to be clear, if you're an employee and you don't show up to work for 5 days in a row, or you don't abide by the dress code, or you misuse email or some company resource, maybe you use the copier to make stuff, right? That's cause, right?
Totally. Well, okay. 100%. It is subjective in the eye of the beholder.
Okay, so Bill Pulte, who is the federal housing director, has literally put out the receipts, as the kids say, literally listed this mortgage issue. So can you just explain, to the extent that you know, like, what is he saying that she did?
So she's listed in multiple places as her principal residence, and she took out multiple mortgages for $200,000+, and then she went ahead and then rented out those homes and did not disclose the income on those homes. So there's a failure to disclose. There is a failure here when it comes to be honest about principal place of residence, which has implications when it comes to getting a more favorable interest rate for the mortgage in general there. This is totally legitimate for cause, Sean. I mean, the notion that this is not a legitimate cause there strikes me as preposterous. I mean, what is a legitimate cause if it is not this? I mean, do you have to literally murder someone in cold blood in the streets of Washington, D.C. and have Donald Trump's National Guard arrest you? I mean, it's pretty preposterous stuff, I think. But
I just want to underscore what you just said, because I back in the late 90s, bought a couple investment properties. And if it's not your principal place of residence, the interest rate that you get charged is higher. And there's also, by the way, additional down payment requirements. If it's an investment property, it's usually 20%. If it's your primary residence, depending on the type of loan, it's lower. So that's legitimate fraud, right?
Yeah, 100%. Absolutely. So if I'm not mistaken, I think it was Georgia and Michigan were the two states where she listed her primary place of residence there. You can't do that. I mean, like, you literally have one primary place of residence there. So you are defrauding a financial institution, which, by the way, just to kind of make an obvious point, we're talking here about a governor on the Federal Reserve. I mean, the nation's central bank there. So, I mean, of all people to be engaged in defrauding financial institutions, I mean, that's pretty ironic for that particular post, is it not?
Yeah, and it's interesting because they're going after Adam Schiff, Letitia James, and now this FedGov, Lisa Cook, for all the same thing, which is, and the funny part is, Josh, I said this a minute ago when I was opening the show, but like when they went after Donald Trump, they literally cooked up charges, made things up that had expired according to statute of limitations. But in these cases, this is legitimate mortgage fraud. Adam Schiff says he's a United States Senator from California. The Constitution requires that you live in that state.
Right.
And if he's listing in the mortgage application that his primary residence is Maryland, or Letitia James says that it's in Virginia when she's the Attorney General of New York, that is like election fraud, mortgage fraud. There's a lot there. That's legitimate, though.
Yeah, and, you know, look, it's kind of funny, for lack of a better word, that all of these high-profile Democrats are being investigated for the same thing at the same time there. It does make you kind of wonder, was it potentially orchestrated? Were they sharing talking points? Were they sharing tips or anything there? I don't really know the details of that there, but it's fraud. It is legitimate fraud. Look, Sean, I can't speak to this personally yet. I'm not a homeowner yet myself there, but I know that when I go to seek out a mortgage, God willing, on our first home here, over the next 2-3 years, whatever the case may be there, I'm going to list this as my principal place of residence in partial part because I want to get a lower interest rate there. This is just a very common thing. I think it's pretty ubiquitous, actually. I think people who are looking to buy homes for themselves as opposed to rental properties there, this is just it's a pretty common bit of knowledge there. And again, for someone like Lisa Cook, who is literally serving on the nation's central bank, the ultimate lender of last resort when it comes to trying to prevent 2007, 2008 style financial crises there, for her to be specifically involved here in defrauding financial institutions, for violating what is a deeply common, if not ubiquitously known rule when it comes to listing a principal place of residence there, it is dripping with irony. It is absolutely fraudulent and is 1,000% a legitimate cause to dismiss her.
So her response was the following. President Trump purported to fire me, quote, for cause, when no cause exists under the law and he has no authority to do so. I will not resign. I will continue to carry out my duties to help the American economy as I've been doing since 2022. Her attorney, Abby Lowell, who represented a ton of controversial figures in the past, put out a statement as well saying that this was illegal. Can you comment on both? Did he have the authority and was it legal?
Yeah, Sean, I think Abby Lowell also was defending Hunter Biden, if I'm not mistaken, during the gun prosecution in Delaware. So, yes. Lowell has a history here, shall we say, of defending a lot of less than fully reputable clients there. I mean, again, I kind of go back to the earlier part of our conversation, which is, I mean, when they say cause, Congress, when they're drafting a statute here, and again, I kind of object on a principle basis to the very existence of these statutes for kind of bread and butter Article 2 executive power reasons. But even conceding that these statutes exist there, Congress, when they want to be specific, Sean, they have no problem getting very specific with the language there. So if they want to say that an individual who is alleged in the public sphere for potentially committing XYZ crimes, that he or she can only be fired for a cause upon being indicted by a grand jury or convicted in a criminal court, a state court, federal court, they literally would have said that there. I mean, this notion that for cause requires some figment of our imagination there. I mean, what about a misdemeanor or felony there? I mean, is Abby Lowell saying that would have to be a felony? Well, what about if it's only a misdemeanor? Is that cause there? I mean, again, if they wanted that kind of granular specifics, they would have put it in there. I think when Congress was drafting this law, they probably had kind of in the back of their mind this implicit understanding that they were already kind of getting into dangerous territory and trying to kind of throw up hurdles and obstacles to the president's ability to dismiss insubordinate employees there. So they probably understood that we're going to get in this sordid business of trying to inhibit the executive branch there. The least we can do is kind of put in these vague words and allow the executive to interpret that a little more subjectively there. And then for all the reasons that we've discussed already there, this is 1,000% a legitimate cause, at least in my personal opinion.
All right, I want one more question on this, and then I want to move on. We got a lot to talk about. This is what the New York Times wrote about this. It said the New York Times respected legal guru Adam Liptak has a go at answering the question that, noting that the Supreme Court decisions have largely upheld Trump's right to fire government officials, which is what you said. The justices have also been clear that the Fed is a very different beast. Instead, the rule suggests needs due cause, which I don't know what that's different than cause, but due cause to fire a central bank governor. And given Cook has not even faced formal charges, let alone been convicted of anything, Liptak concludes that Trump is probably overstretched. That conflicts with everything that you and I just agreed on is actually probably true.
So I think the interesting question, and this is an interesting academic question that could soon potentially see some very legitimate litigation and potentially an extremely high-profile SCOTUS case. But the very interesting question, and one that I had been wondering and debating since my very first days of law school, is what is the Federal Reserve exactly? I mean, is the Federal Reserve simply the latest incarnation of the original Bank of the United States that was upheld in McCulloch versus Maryland, the famous John Marshall case in 1819? Is that simply what the Fed is? Or is the Fed something different? And the history of the Fed, that when it came into being during the Woodrow Wilson administration, 1913, 1914, right around then, Woodrow Wilson is the godfather, essentially, of the American administrative state. He is the OG administrative state bureaucracy guy. So the Federal Reserve, when I kind of read the history of the Federal Reserve there, it was intended to be an agency in the administrative state, just like all these various other alphabet soup agencies there. So from that vantage point, there's nothing particularly different about the Fed than the DOJ, Department of Labor, any of these organizations there, literally any of them there. And from that vantage point, the notion that the president does not have core Article 2 authority to make hiring and firing decisions is utterly preposterous. So I think that Lisa Cook's defenders, they're going to have to get on very interesting historical ground and basically try to make the argument that, no, the Fed actually is qualitatively different than all of these other federal agencies there. It's not necessarily in the executive branch. It's not necessarily part of the Congress, the judiciary there. It's kind of just an independent, kind of quasi-private charter there, analogous to the original Bank of the United States, kind of, sort of there. It's potentially setting up for a genuinely, for us constitutional law nerds and us American history nerds, potentially genuinely intellectually stimulating Supreme Court litigation. But again, my reading of the history of the Fed was that this was intended to be very similar to all the rest of the administrative state there. And from that vantage point, the president has Article 2 ability to make personnel decisions just like any other agency.
All right, I got a bunch of topics that I want to hit real quick in the time that we have remaining. But one last question. When she walks in the door, if she tries to go to work today, I know you're not the head of HR, but as a lawyer, what would you have told HR? Do you let her back in the building until it's adjudicated, or do you say you're fired until the court rules otherwise?
If I were giving the Trump White House advice there, I think that's a legitimate, keep her out of the building situation there.
Okay.
Look, I mean, what's the point of firing her unless you're going to actually fire her, right?
No. But I mean, if you're the Fed, so you're Chairman Jerome Powell, and she says, I'm fighting President Trump on this, I'm coming to work today. Do you go, hey, until you get the court to rule in your favor, I can't let you back in the building? Or do you say, great, I'll let you back in the building until Trump fights it out? Like, someone's got to win on that.
So, this is another interesting question. So my own theory of constitutional interpretation is that all three branches, Article 1, Article 2, Article 3, have an independent obligation to interpret and enforce the Constitution. So what that means, that the president has not just the ability, but indeed the obligation under his own oath of office to interpret and enforce the Constitution regardless of what the courts say. So from that vantage point, Donald Trump's word when it comes to executive branch goes. But, I could see a world in which Jerome Powell might kind of take the old judicial supremacist view whereby nothing is official until a bare 5-4 majority of the court rules on it. That's just simply not my reading of the ultimate question of who gets to decide what the Constitution means. Okay.
Next thing, yesterday the president talked about flag burning. I think my interpretation of this, again, as the guy that never went to law school, is that while this 1989 law is very clear that you do have a constitutional right, as abhorrent as you and I or anyone else might find it, you do have a right to do it. But what the president did was nuance it, which said, if it incites violence, legal or not legal?
Sean, I would actually go even further than this executive order. I actually had a whole episode on this on my show earlier today, the Josh Hammer Show. I actually think that Texas v. Johnson, which is the 1989 case, and then the companion case the very following year called U.S. versus Eichmann, these are both narrowly decided 5-4 decisions upholding the constitutionality of flag burning as protected speech. I actually disagree with those decisions because to me, the act of burning the American flag is not speech, it is conduct. It is the same type of any other kind of conduct there, especially in this particular case involving fire, blazes, arson, potentially kind of dangerous behavior there. That is totally the kind of thing that is not an absolutist First Amendment right and that ought to be regulated by various governments from the local government all the way up, I would argue, to the federal government itself. So I would actually go, frankly, even further than the Trump executive order, although I do love the notion that it's at least trying to potentially kind of sow some seeds of doubt, shall we say, in those two Supreme Court cases there. This kind of gets to what I was just saying a minute or two ago, which is that this is my theory that Article 2, the executive branch, has a robust obligation to interpret the Constitution according to its own understanding, as opposed to the courts. Very similar thing, by the way, when it comes to birthright citizenship. Again, the president can make these decisions for himself, regardless, essentially, of what the courts say, except when it comes to the literal named parties in an actual Article 3 case or controversy before the courts there. But with all that aside, and my kind of first principles disagreements on the Johnson-Eichmann cases there, Yes, your understanding is correct that the executive order at face value is pretty narrow, actually, there. It does accept Texas v. Johnson for better or for worse. Again, I actually say for worse, but it does essentially accept Texas v. Johnson, says, but this is not applied to fighting words doctrine, incitement there. The fighting words doctrine, this goes back to a 1942 case called Chaplinsky. This case gets invoked a lot. It's actually been watered down, to be honest with you, over the years. So it's not necessarily the most robust doctrine to cite to, if I'm being very honest there. It's maybe something of a stretch there, which is kind of why I actually take the, let's call it the more extreme position that this whole thing is actually wrong there. But, I mean, the point of this, Sean, as you and I know, it's not necessarily kind of for the law here. I think why President Trump is doing this is just to make Democrats defend flag burning. I mean, it's a very, I mean, it's literally just a brilliant instance of Donald Trump yet again mastering the art of the 80-20 issue, let's call it.
It's funny, as you're saying it, I was thinking to myself, one angle of this, and again, I don't want to go, I got 3 more things I need to get you 1-minute answers on each, but it's like, okay, if you're lighting a fire outside, that might be regulated too. I mean, you can't just go light stuff on fire in the middle of the street, regardless of whether it's a flag or a piece of paper. All right, 60 seconds or less on each one. Intel, the president wants a 10% stake. I trust Donald Trump as a businessman and as a negotiator. I worry about the precedent this sets in the future. Are you concerned?
Potentially, but I'm not freaking out either. Look, I mean, public-private partnerships have a very long history in the United States there. I mean, the notion, Al Gore gets made fun of for saying that I invented the internet, but he was kind of making fun of this notion, which is a legitimate one, that the public-private partnership, the government did work hand in glove with private industry to develop the internet. There's a million examples. DARPA, exactly there. So, the notion that the government could be involved in helping these extremely important chip companies there to try to get us less reliant on Taiwanese chips, I don't have an issue with that. I do have an issue if the U.S. starts actually voting on its shares there. So that's kind of where I draw the line personally, but let's see how it goes, I guess. Okay.
Next, Abrego Garcia. They want to deport him to Uganda. Does it matter where they deport? I mean, I guess my issue would be if you want to deport somebody and we're going to do it, I know we already tried it back to El Salvador where he's from, but I don't know how is it legal to send someone to a country that you're not from, to deport them? Is that legal?
Well, it just depends on the bilateral agreement that the United States has reached with that particular government, actually. But earlier this year in a case in June or July, I forgot the exact date, SCOTUS did uphold the legitimacy of these third-party removals, actually. So the only kind of debate right now, his lawyers are making a habeas corpus petition. That's why this radical lower court judge, Judge Zinnes, has granted a temporary injunction. But that injunction is going to expire. So his lawyers are basically arguing that it should be Costa Rica, not Uganda. That's ultimately going to be the debate here. Personally, I don't particularly care. I'll be honest with you, it really makes no difference to me as long as he's out of the United States.
Yeah, I'd rather go to Costa Rica than Uganda.
I agree.
I don't know. I haven't been to either, but I just assume I'd rather be in a Caribbean
Costa Rica's
country.
Beautiful.
Yeah, it is. I've heard great things. Many people are saying. All right, on the census, big discussion about, JD talking about over the weekend, whether or not the impacts of counting illegals, right? You don't count diplomats in our census. You don't count tourists in our census. Why do we count people that are legal? Does the Commerce Department have standing when it comes to this to make it actually happen? So we only count citizens?
Yes, 1,000%. Well, so the citizens part is a little more complicated. So Section 2 of the 14th Amendment does say that all persons have to be counted. And notably, Section 2 of the 14th Amendment actually uses the separate word citizens like 1 or 2 sentences later. So kind of looking at that in tandem there, it does seem to me like they intend to be counted green card holders, permanent residents there. But that's the difference, right? Is between someone who is legally here, long-term basis, green card, LPR, versus a illegal alien. If you're an illegal alien, you might physically be here, but legally speaking, Sean, you're not here. They should not be counted. Period, full stop, end of story.
All right, last subject that I want to cover. President Trump's deployed troops, National Guard troops, to D.C. By the way, I always tell people this. When you get off at Penn Station, New York, they're there too. So I don't know why all these Democrats are freaking out. They haven't said anything since 9/11 about them in New York City. But anyway, there's talk of sending them to other cities. D.C., in my mind, is very unique. How can the president, what authority does he have to send National Guard troops into states that isn't a violation?
So D.C. is totally unique. You're totally right about that, which is why you have this kind of broader federalization of the D.C. Metro Police. And D.C. was supposed to be a federal district. I mean, in my notion, the D.C. Home Rule Act of 1973, which is this experiment in D.C. governing itself, is probably facially unconstitutional, to be honest with you. So that that'll be another kind of interesting litigation if that statute is challenged. So he definitely does have more limited authority when it comes to any other city. But he, of course, does have authority to send in National Guard when there is some level of insurrection, anarchy. We saw it in Los Angeles just in June, actually, during kind of the anti-ICE, anti-immigration riots out there in Los Angeles in June. You know, he sent in the National Guard, and there was litigation. Some left-wing judges were trying to stop it there. But he has statutory authority there under the Insurrection Act of the late 19th century, various other statutes as well. He absolutely has the ability to send in National Guard as long as you meet certain legal thresholds there. And that's kind of where the rubber meets the road there. It's going to be a very case-by-case basis, I would say.
All right. Josh Hammer, I always feel smarter when you're on the show. I appreciate everything you guys do at the Article 3. I love your show. Thanks for coming on, as always. Well, if you enjoyed this content, make sure to like this video, subscribe, and click the notification bell to get more.